I've been up here several times and I understand their concerns, but I think we're, like Mr. Robustello just said, we're waiting for what the judge determines it's going to be. It's a legal issue and we're not the judge and the juror here. That's in their court, it's not in our court. Once we hear what that's going to be, then we can get Mr. Robustello to give us a rundown of what that means for the city. But until then, we're out cold.
The city would be the owner, Your Honor, of this alleged road. It would have the duty to maintain and operate the alleged road. This matter cannot equitably be adjudicated without the participation of the city.
Why isn't the remedy for that joined to the city?
In the absence of the other procedural issues, that would be the remedy, but because of the fact that this should be a Land Use Petition Act appeal, and because the time for appealing the Land Use Petition Act, it's too late to join the city.
At this point, I'm prepared to rule. Turning first to the oldest motion, which is the procedural grounds motion, I am not persuaded that this action is really a LUPA action, and so nor do I think that the CUSOs were bound to proceed administratively. So I think all of those grounds are denied.
It is a closed record proceeding. So my question is, there's been several citizens been up in front of us talking about right-of-way issues and such. And I want to know how that does or does not have a bearing on this.
Council, my understanding is that the right-of-way that's been referenced recently does implicate one of the plat proposals at issue.
That should be thrown out of the review. It won't be a part of this review. Because it's not, that didn't go to the hearing.
That is one issue that I believe was raised below, and that is an issue that you'll have to address during your review in the closed record.
It was raised at the hearing exam.
I believe so, Council. And I believe that you can see that for yourself when you do undertake the record review process.
I only have comments about the process that is leading up to the hearing, not the materials that are in the testimony.
Let me check that. Mr. Lell, can you clarify, please?
Council, this matter is pending before you in a closed record, quasi-judicial setting. My consistent advice to the Council is not to accept public testimony on this topic, even on matters of process. I'm uncertain about what the content specifically of Mr. Mason's comments would be, and I obviously can't preemptively address those, but this is a matter that's going to be coming before you in closed record, and again, my advice is not to accept testimony on this at this time.
I'm sorry, Mr. Mason?
That's the problem. That's what I had to speak about right there.
This is a process issue. This is not a content issue. And to keep shutting citizens down is irresponsible. You cannot be preemptive. You're sitting there. That's why we pay you to sit there. If something comes up that's of concern, you can discuss it at that time.
Deputy Mayor Stecker, we're going to take a recess.
You have my advice, and the Council is obviously free to disregard that.